everybody. Thank you very much for joining us in this seminar about blue justice. We are very happy this afternoon to welcome Thomas Leclerc. He will develop a specifically interesting topic today about the famous BBNJ agreement, and especially the question of equity in this agreement and in law of the sea. Thomas Leclerc is maître de conférence in public law, maître de conférence to say associate professor, and is working especially on international spaces, especially so in spaces beyond a national jurisdiction. So without taking more of your time, I will just leave the address of the seminar in the chat for the people who are interested, and I leave the floor to Thomas.
So good afternoon, everyone. It's a great pleasure to be here with you today and to share some reflection on this concept of equity at sea. Thank you so much to Betty and Olivier for inviting me to discuss this really interesting topic. So the topic of my intervention will be marine resources in areas beyond national jurisdiction. As everyone may know, the instrument on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction has been formally adopted last Monday in New York. So we can work now on the official agreement, not only on a draft. So this agreement has been adopted, but not yet entered into force. And I am taking this opportunity to try to analyze this new BBNJ agreement in light of equity consideration. This presentation is also kind of a kickoff for a new research project I am currently starting with a team of researchers in public international law on issues linked to the concrete implementation of this BBNJ agreement. So in that sense, I will maybe today ask more questions and draw some legal hypotheses than to reach definitive conclusion. So first, about the scope of my presentation. So I will deal today with marine resources in areas beyond national jurisdiction. When I'm talking about areas beyond national jurisdiction, I will be talking about the legal regime of the high seas and Part 7 of the United Nations Convention on the Law of the Seas. Is it still working?
Yes, it's working
okay.
Fine. Thank you.
Perfect. Part 7 of UNCLOS for the legal regime of the high seas. Part 11 of UNCLOS for the legal regime of the seabed and ocean floor and subsoil, a maritime zone called the area by UNCLOS. And of course, I will be talking about marine genetic resources with this new BBNJ agreement. So you have areas beyond national jurisdiction, you have marine resources, and here today I will focus on fishing resources for the high seas, mineral resources for the area. Indeed, Article 133 of UNCLOS limits the scope of Part 11 of UNCLOS to mineral resources in situ in the area, and marine genetic resources defined by the BBNJ agreement as any material of marine plants, animal, microbial, or other origin containing functional units of heredity of actual or potential value. So I'm dealing with areas beyond national jurisdiction, with marine resources, specific marine resources, and with activities related to these marine resources. So I'm dealing with fishing or fishing-related activities for the ICs, with deep sea mining for the area, and with like utilization and commercialization of marine genetic resources. In this matter, I will really focus my presentation on activities linked to the generation of benefit coming from mineral resources activities or marine genetic resources activities. Well, as my domain of research is public international law, maybe as a general introduction, I should try to explain the relation between equity and international law before going into the specific analysis of the BBNJ agreement. Well, when you look at equity, the concept of equity in the specific branch of public international law, you will find that equity kind of has an historical relation with public international law in a specific issue, which is the administration of international justice. Equity is, you will not find a precise definition of equity in public international law. But in a very technical meaning, equity in international law refers to the power conferred to the International Court of Justice or to another international court or tribunals to decide a case, we said ex aequo et bono, which means without being required to apply rule of law. And you will find the main illustration of this with the Article 38 of the Statute of the International Court of Justice. You have to look at the second paragraph of this article saying that the power of the court may be to decide a case ex aequo et bono if the parties agree thereto. So basically there is this kind of power of the court with the consent of the state party to the dispute to decide the case by applying a general principle of equity, not specific sources of international law. But this is a very specific technical meaning. In a broader sense, in a broader meaning, equity refers to what is fair and reasonable in the administration of justice. So the judge does not have the power to legislate, to create rule of law, but the judge has some discretion in interpreting and applying legal rules to concrete situation. And this is in this area of the discretion given to the judge that equity may operate. So basically the most common conception of equity in international law is then kind of a subjective conception. Equity corresponds to the search for justice by the judge while facing concrete cases. So in that sense, equity is really like a matter of abstract justice. So that's kind of the historical link between equity and international law. But there is kind of an evolution, and now you will find express reference to the term equity in some international legal rules. And the law of the sea, as a specific branch of public international law, is kind of a very good illustration of this evolution. A perfect example is the issue of delimitation of specific maritime spaces, exclusive economic zones, and continental shelf, for example. And here I provide the example of case law by the International Court of Justice from 1969 in the North Sea continental shelf cases. So this case concerns the delimitation of the continental shelf between states with opposite coasts. And the state parties asked to the judge to state the principle and rules of international law applicable for this delimitation. And in the judgment, the court found that the application of the equidistance method will lead to an unfair result, and it reveals the existence of a rule of law which require states to draw the lines, the delimitation of the continental shelf, in accordance with equitable principle. And what I find interesting here is the quote from the case. The judge are saying that here it's not a question of applying equity simply as a matter of abstract justice, but of applying a rule of law which itself require the application of equitable principle. So not equity as an abstract, as a principle of abstract justice, but equitable principle which are required by a specific rule of law. And today you will find these international legal rules in UNCLOS, Article 74 for the delimitation of the exclusive economic zone, and Article 83 for the delimitation of the continental shelf. In each case, states have to draw the line in order to achieve an equitable solution. But what you have to keep in mind, and maybe to what have to be really underlined here, it's whatever notion of equity you choose to keep, a notion of abstract justice or the express reference by rule of law in the form of equitable principle, only the judge at the end of the day will be confronted with equity, and only the judge must give to the equity concept a specific direction and a specific content. This is why I choose a quote from a famous article of Public International Law on this concept of equity. I will translate. The author is saying that for the lawyer, this is the link, the relation between equity and the judge, which constitutes the main issue in public international law. And I think we should keep that in mind when we're trying to analyze the BBNJ agreement in light of equity consideration. So let's now go into this BBNJ agreement. If you have a quick scan of this agreement, you will find 17 references to the concept of equity in the text. And 12 references are directly linked to marine genetic resources activities. And if you go into one interesting article, Article 7, you will find that the agreement is saying that in order to achieve the objectives of this agreement, parties shall be guided by the principle of equity and the fair and equitable sharing of benefits. This Article 7, it's kind of, it's not easy to understand and to interpret this Article 7. We'll see in the practice how we should give some meaning to this general article. It's kind of a catch-all article. I will come back to that. But after a quick reading of this article, one may say that we are facing here in this article one general principle, the principle of equity, and one more concrete approach, the fair and equitable sharing of benefits. So I will divide my presentation in two parts. First, I will address the fair and equitable sharing of benefits approach. And in a second part, I will try to reflect on this principle of equity, meaning and maybe potential implication of a general principle of equity. So let's start with the fair and equitable sharing of benefits approach in this new domain, which is marine genetic resources activities in areas beyond national jurisdiction. So the fair and equitable sharing of benefits approach is one of the main objectives of the BBNJ Agreement in part 2 of this agreement dealing with marine genetic resources. Here you have Article 9 saying clearly that one of the objectives of this part are the fair and equitable sharing of benefits arising from activity with respect to marine genetic resources. Well, this approach, fair and equitable sharing of benefits, it's not a new approach of equity in international law. You will find, for example, this approach with respect of genetic resources in the Convention for Biological Diversity, 1992, and its Nagoya Protocol from 2010. But in this presentation, and as I'm trying to focus on marine resources located in areas beyond national jurisdiction, I will propose kind of a comparative analysis between part 2 of the BBNJ Agreement and the legal framework applicable to deep sea mining, which means part 11 of UNCLOS. The starting point is similar for the two legal regimes. The starting point is that activities shall be carried out for the benefit of all humanity. You will find that in Article 140 of UNCLOS. Activities in the area shall be carried out for the benefit of mankind as a whole, and taking into particular consideration the interest and needs of developing states. Accordingly, the International Seabed Authority shall provide for the equitable sharing of financial benefits. And in order to achieve this objective, there is a need for a financial mechanism. When you look at the BBNJ Agreement, it's really similar. MGR activities shall also be carried out for the benefit of all humanity. And accordingly, the BBNJ Agreement say that the benefit arising from marine genetic resources activities shall be shared in a fair and equitable manner, Article 14. And once again, in order to achieve this objective, there is a need for a financial mechanism. And in that sense, monetary benefits shall be shared fairly and equitably through the financial mechanism established under Article 52. So the starting point is quite similar. When you look at the decision-making process and the modalities for the application of this approach, here, and we start with the legal regime for the deep sea mining, you have to take into account one specific agreement, an agreement adopted in 1994, because this specific agreement will deeply modified the modalities for deep sea mining as it was defined by Part 11 of UNCLOS. So it's a very important agreement to try to understand the legal regime for deep sea mining, because the modalities for the sharing of benefits and the decision-making process have been deeply modified by such agreement. So the logic of internationalization of the regime stayed, was preserved, but the modalities for the deep sea mining have been almost entirely abolished by this 1994 agreement. So today, basically, you have a finance committee, part of the International Seabed Authority, who has the first responsibility to draft rules and procedures on equitable sharing. And then the assembly of the authority have the power to decide on the equitable sharing of the benefits. But this power to decide given to the assembly, it's not, well, it's much more appropriate to say that it's the right to consider and approve the recommendation of the Council of the ISA, the International Seabed Authority. So it's kind of, it's only the power to consider the recommendation of the Council and to approve the recommendation of the Council. The basic principle for the Council to recommend and to adopt a decision is the consensus, a principle often underlined as a well-suited principle for equity concern. But the devil is in the details. And when you go into the details, you will see that if all effort to reach a decision by consensus have been exhausted, decision may be adopted by a vote that should be taken by a 2/3 majority of members present and voting, provided that such decisions are not opposed by a majority in any one of the chambers. And these chambers are a creation of this 1994 agreement. So basically there is 4 different chambers. The first 3 chambers represent the interest of developed state parties, and the 4th chambers represent the interest of developing state parties. In conclusion, basically, this 1994 agreement create kind of a veto power for developed states in the decision-making process. Well, now when you go to the BBNJ agreement, you don't have an organization created as the International Seabed Authority. The key role is given to the Conference of the Parties, who shall decide on the modalities for the sharing of monetary benefits. Once again, you will find the search for the consensus, which is a principle, but also a way to adopt decision without consensus. I will not go into all the modalities, but basically you have a special fund created to receive the payments coming from marine genetic resources activities. And which is interesting, some modalities are given by Article 14, and you will find the modalities here. The modalities of payments to the special fund can be milestone payments, payment or contribution related to the commercialization of products, and so on. It's similar, but not exactly the same modalities and decision-making process for the legal regime on deep sea mining and for marine genetic resources activities. Today, you have a discussion at the International Seabed Authority on the specific design of a benefit sharing mechanism for deep sea mining. I will not go into too much detail. You can listen to a very interesting webinar dealing with the design. And I'm showing some illustration of this webinar on this slide. Actually, the first webinar of the Blue Justice series was dealing with the specific design of a benefit sharing mechanism for deep sea mining. But what I would like to say is that the current discussion taking place at the International Seabed Authority are quite essential because they may set kind of a precedent for other global common resources in the future, like marine genetic resources, or you can even think about celestial mineral resources. So it's interesting to see to have a look at this current discussion. And basically you have two options on the table. The first option is to adopt a formula for equitable sharing, and 3 alternative formula has been developed and tested by the International Seabed Authority. Each formula will take into account two criteria: the population of each state party as a percentage of the total population of all state parties, and a social distribution weight calculated by reference to the per capita gross national income of each state party. What is interesting is that there is already some analysis of this option, and different authors reach the same conclusion, saying that the direct contribution of the funds will lead to states receiving economically insignificant benefits. And here you can have a look at this article from Marine Policy on equitable sharing of deep sea mining benefits. Indeed, not all the money received and collected by ISA will be available for equitable sharing. First, the administrative expenses of the authority must be deducted from the revenue received, and then a portion of the fund will be used to assist developing countries which suffer serious adverse effects on their exports of mineral resources. So that's the first option. The second option will be to create a seabed sustainability fund and to use the amount received by the authority through this seabed sustainability fund. And the general idea will be to use the fund to basically help promoting increased knowledge and sustainable use of the resources, and to improve the protection and preservation of the marine biodiversity. And then what about the BBNJ agreement? Here you have the Article 52 on funding, which say that the money collected shall assist developing state parties in implementing the agreement. And this article creates a special fund and a global environmental facility trust fund, which should be used to basically help reaching the main objective of the agreement. So some brief question and conclusion related to this first part, as I'm checking my time and I don't have a lot of time left. First observation: if the monetary benefits from deep sea mining or marine genetic resources activities are used through a sustainable or an environmental fund, one may ask if it's really a fair and equitable sharing of benefits among state parties to the agreement. And if the monetary benefits are shared among state parties, I will make two main observations. The first one is that this approach cannot move away from the need for concrete references. Equity here is not an abstract rules. You need concrete elements like the population of each state's parties or the gross national income of each state parties. But the choice for these concrete references will be decided by policy-making bodies. And such bodies, unlike international court or tribunals, may not be considered as impartial. So the only guarantee will be that the legal obligation for states to make all efforts to reach consensus, but maybe we can discuss if it's enough as a guarantee. And my last observation will be linked to enforcement issues, because in Part 11 of UNCLOS, the area and its resources are the common heritage of mankind. And by application of this legal rules, activities in the area have to be organized, carried out, and controlled by the authorities. Basically, all the activities in the area shall be carried out in accordance with a formal written plan of works approved by the Council, and the authority have to exercise a control over the activities. So, well, we can discuss this aspect, but you have some enforcement guarantee in this specific in part 11. When you look at the BBNJ agreement, you don't have like basically marine genetic resources are not qualified as common heritage of mankind. So activities with respect to marine genetic resources may be carried out by all parties, not on behalf of one specific international organization. The only guarantee is that parties, when they carry out activities with respect to marine genetic resources, has to do it in accordance with the agreement. And you have a creation of an implementation and compliance committee, but once again, we can ask if it's a sufficient guarantee for enforcement issues. So now I will go into the second part, and I will try to be to sum up some of my observation linked to the principle of equity. So let's go back to Article 7, saying that basically you have the fair and equitable sharing of benefits approach, but you also have the principle of equity. So in order to achieve the objective of the agreement, parties shall be guided by the principle of equity. So besides this fair and equitable sharing of benefits approach, one may then try to indicate the existence of a distinct and stand-alone principle of equity. And such principle shall guide state parties in implementing not only part 2 of the agreement on marine genetic resources, but all the parts of the agreement. Well, for part 5 on capacity building and the transfer of marine technology, it does not really come as a surprise. And actually, there is not only monetary benefits, but non-monetary benefits that shall be shared in accordance with the agreement and in equitable form. And basically, capacity building and transfer of marine technology may be considered as non-monetary benefits that shall be shared in an equitable manner. But it may nevertheless be more difficult to argue that the principle of equity should also guide state parties in implementing part 3 of the BBNJ agreement, measures such as area-based management tools included marine protected areas, and part 4 of the agreements related to environmental impact assessments. And when you look at the BBNJ agreement, you will find no reference to the term equity in these parts of the agreements. So I try to go into the preparatory work of the BBNJ agreement to see if we can have some clue in the affirmation of a stand-alone principle of equity. When you go into the draft prepared for the 3rd session of the negotiation in August 2019, and when you go into the article dealing with general principle and approaches, there is actually no reference at all to the equity concept. Only the fair and equitable sharing of benefits approach is mentioned as one of the objectives of part 2 on marine genetic resources. When then you go into the draft text for prepared for the 4th session, March 2020, the principle of equity was included in the article dealing with general principle of approaches, but only the principle of equity, not the fair and equitable sharing of benefits approach. Then when you go into the draft prepared for the 5th session, February and March 2023, you have two options on the table: the principle of equity or the fair and equitable sharing of benefits. And we arrived to the agreement adopted last Monday in New York, when you have actually both the principle of equity and the fair and equitable sharing of benefits. So how can we interpret this evolution? It's not easy. Option one will be that the choice was made to don't make any choice. That's why we can say that Article 7 maybe look as a catch-all article. You put everything inside without trying to choose between principle of equity and the fair and equitable sharing of benefits. Or option two, state parties decided to keep the principle of equity as a stand-alone principle next to the fair and equitable sharing of benefits approach, which may lead to a question as looking as the principle of equity as kind of a guiding principle, not only for marine genetic resources activities, but for other parts of the agreement, the use of resources in general, and the conservation of resources, or even for the protection of the marine environment. And actually, when you have a look to a policy brief of the International Seabed Authority, this policy brief is saying that UNCLOS, here I'm looking at deep sea mining, identify non-monetary benefits such as the orderly, safe, and rational management of the resources of the area. And to this list, can also be added the non-monetary benefits that accrue from the protection of the marine environment. So you can try to have this evolution of looking at equity as something which is not only for the sharing of benefits, but a much more broader principle of equity that should also apply to the conservation of the resources and even to the protection of the environment. In that sense, and I didn't talk about it, when you look at the IC legal regime, part 7 of UNCLOS, there is a freedom principle. The ICs are open to all states and the freedom of fishing, but you also have as one of the main conditions for the using of this freedom of fishing, the legal obligation of conservation of the living resources of the IC. Is it kind of a form of equity in the access, in a long-term access to the fishing resources? I'm only asking the question. So my basic conclusion will be to ask ourselves if we have today kind of equity as a multi-level concept. Actually, when we try to look at the BBNJ agreement, are we dealing with equity as a multi-level concept? First, the confirmation of a concrete approach of equity in the form of the fair and equitable sharing of benefits approach, but also principle of equity as a general and abstract principle. So here, and I'm coming back to my introduction, if it's the case, we will have a shift away from the traditional application of the concept of equity in international law, because as I say, equity in public international law was much more a form of fair and reasonable administration of justice by international courts while facing concrete situation. Here, we will have a very broad and abstract principle, and I'm coming back maybe to the preamble of UNCLOS, saying that the objective of the convention is the equitable and efficient utilization of marine resources, conservation of these resources, and the study, protection, and preservation of the marine environment. And the achievement of all these goals will contribute to the realization of a just and equitable international economic order. Sorry, I have been a bit long, but thank you very much for your attention.
Thank you a lot. Thanks a lot, Thomas. That was very informative. Now we have a bit of time for questions and comments from participants in the webinar.